Okay, you're very welcome back to the 9 till noon show on the programme. On Monday Focus now, we're going to be talking all things wills, and to help lead us down this path is Gillian McGough, Associate Solicitor at McElhinney and Associates in Stranorlor. Good morning to you. Thanks for joining us.
Good morning, Greg. How are you?
Good. It's great to have you on the show.
Thank you.
And this is one of those issues that exercises people an awful lot. I mentioned, we have a regular slot here where we talk about legal matters. A lot of the questions are about wills. A lot of them after the fact.
That's right.
Very few questions come in saying, I am making a will.
Yes.
What shall I do? So is preparation, planning and understanding, is that the key to avoiding as many issues as possible?
Issues after the day. Yes, Greg, it's very pertinent. So, like estate planning, I suppose describing what it is first, estate planning is putting a plan in place during your day now, while you're alive and well and have capacity to deal with all of your assets and your affairs for both during your lifetime and after your day. So I suppose the most basic form of estate planning that everyone would be familiar with is a will. And a will, obviously, it speaks from death, and it deals with the distribution of your assets after your day, and you nominate who is to inherit those assets after your day. So that's the most basic form of estate planning. Most people will be familiar with that, and it's extremely important that people do put a will in place.
But we struggle to overcome, a lot of people out there, clearly. Some of us are just tardy and don't do it, but others think, well, I don't really want to talk about death.
Yeah, it's a bit
and
morbid,
I think
all right.
that is what the blocker is.
Yes, it
for
is.
a lot of people.
It is. But I think if people are aware of the consequences of not making a will, that might be the big push to bringing them to the office to make a will. So I suppose the most important matters that people should be aware of if they don't make a will is really they've lost control of the assets and how they're distributed after their day, because the Succession Act very stringently sets out who's entitled to the estate if there's no will. And those are persons who may not be your intended beneficiaries after all. Not only is that loss of control in who's going to benefit, but you've also lost the chance to tax plan that succession and transfer of the assets, particularly if you find you have a big, there's a business asset or a big farming asset. Valuable assets, and they then end up in the hands of beneficiaries that you never intended.
Yeah, but I think particularly with the farming one, let's use that as an example, or a business one, I think people don't want to open up a can of worms whilst alive. Say everything's working out well, do you know what I mean, and everyone knows their place and everyone's getting on well, then if you start sort of getting people around the table to talk about what you might want to happen after your death, I think people will be afraid that maybe, a particular person in the family who's very useful around the farm might think, well, you know what, I'm not getting enough. I'm not, do you know what I mean? Yeah. Do you think there's, and I think the IFA actually had a meeting on this not so long ago, there's a fear that if you start opening up the conversation about, big assets, that it could cause problems whilst you're alive? Actually,
it's the one thing I do advise clients to do is have that conversation with family members. Do have it, because then you'll know whether they do have an interest in that asset or not. And most people will find, surprisingly, that maybe the children don't, or use the farming asset that maybe one person is farming, and has given up their whole life and, to farm the lands. And I mean, if you don't plan it, the tax consequences as well can be extraordinary for some beneficiaries.
Can you talk a wee bit more about that, about the difference between taxation, tax implications, and when you make that will or if you don't make the will?
So, there's tax consequences either way, but, if you don't make the will, I suppose the beneficiary inheriting has a tax-free threshold, and that very much depends on the relationship of the beneficiary to the person who's passed away. So the largest tax threshold is $335,000, and that is from a parent to a child, or it can be actually from a child to a parent in certain circumstances where the child might have predeceased the parent. And that seems like a huge tax threshold, but it may not be if the farm asset is worth €1 million or a business asset or thereabouts. And then the next tax threshold would be, a brother, sister, niece, nephew, grandchild, or, another lineal descendant like that. That's $32,500. It's not particularly generous.
And just in relation to what might appear generous on the face of it, because there's cash rich, I suppose, and then there's asset rich. But these are assets that you may never intend liquidating, and then you're faced with a bill on those, and you're thinking, well, how do I work this out?
Well, that's it.
Yeah.
And that's where the beneficiaries find themselves in difficulty. I mean, who has the cash? readily available to pay the capital acquisitions tax. I should say that those thresholds are what you can inherit tax-free. Anything over and above that is taxed at 33%, so it's almost a third, you know. And what happens is the beneficiaries find that they have to, as you just mentioned, liquidate and sell the asset. That then can lead to disputes and disgruntlement within families, seeing family businesses having to be sold, family farms having to be sold, which could all have been avoided if there was a will in place with the intentions of the testator set out very clearly. And even when there's a will in place, there are tax incentives there that can be examined, if you like. So we'll touch on the agricultural lands again. There's a sizable relief there on agricultural capital acquisitions tax. So where the beneficiary meets certain conditions and where the asset passing is a certain asset, there can be an agricultural relief. It's a 90% reduction on the market value. So, you know, it's only 10% capital acquisitions tax for the beneficiary. But obviously it has to be planned, and there's certain conditions there for a beneficiary and the asset passing. Similarly with a business, there's also a 90% reduction there in the taxable value of the CAT, as long as it's a proper business asset that's passing, and again the beneficiary can meet the conditions. Now you'll often find that a testator coming in, if they're armed with that knowledge, they can almost prepare the beneficiary, or the beneficiary can take active steps to try and fit the mould, if you like, of
and I
that.
think on those more complex matters, you really need a broader consultation, don't you, with the likes of yourself, because there's a lot to tease out there. Can I give another scenario then? So let's just say, and I think this is probably more representative, though we are a very rich agricultural county in terms, I don't say rich, I mean in terms of how many of them we are. Right, but so say I am married, right, with 4 kids, 2 girls and 2 boys, right? What happens if I die without a will in that scenario? Who gets what?
So you're married with children, and you
2 boys, 2 girls.
And you make no will. So it's 2/3 passed to your surviving spouse, and 1/3 of the estate then among your children.
Right, which divvying that up would be complicated.
Of course it would be complicated, and then you find you might be minor children, and then the spouse has to take it as trustee. Causes all sorts of difficulties.
Right, so I make a will now, right? But I don't want my eldest son getting anything because he's a bit of an idiot. Let's just say hypothetically, right? So what can I do in a will? Can I literally put what I want, exclude the eldest, maybe exclude the youngest daughter because I don't like her husband, right? No, but I'm just saying hypothetically, I don't have this family set up. So can I say, right, I want it to go to my wife and I want it to go to the second oldest son and the oldest girl, but I don't want the other 2 getting anything. Can you do that in a will if you wanted to?
Yes, well, let's just start by saying, you know, it's your will, and to some extent a testator has what's called testamentary freedom to some extent. And then it's my job to row in and tell you what could potentially happen.
Exactly,
all right? So what you're talking about there is disinheriting a child. So it's a Section 117 in Succession Act, right? So that child, where they feel disgruntled, can come back into the estate and make an application that they were not provided for in the estate, where they feel their parent has failed in their moral obligation to provide for them either during their lifetime or after their day. So then, you know, I would try and ascertain from you, well, what provision have you made for them during their day? I mean, were they educated? Did they have an expensive college education? Did you provide them with a lump sum? Were they given a site to build a house? That is provision, you know, and then just you choose to not leave them out of the will. Is that the reason you're leaving them out of the will? Because they've already been provided for? Or are they simply frivolous with money and they're irresponsible, or do they have an addiction problem? All of that is very important.
My questions was quite extreme, but it was just get into exactly the type of stuff you're talking about, that everything's not black and white.
It's
really,
not black and white.
And also your role really to do this correctly is probably more important than just being a witness or whatever it might be, that you're a check and balance
capacity,
there. Okay, get you right. All right, good stuff. So in terms then of making a will.
Yes.
What? How do I do it? I'll come into you.
Make an appointment, come into me. And I always tell people, if you can gather together a schedule of your assets, put together, you know, I don't need to know money's worth, just let me know what bank account you have, life policies, shares or investments, business assets.
Caravan?
anything.
Yeah,
anything. Cars, holiday homes, dwelling house, and then I take a list of that. I also take a list of any liabilities. Like
all accounts too, because I think often sometimes people don't log little accounts that they might have here and there.
That's it. Well, if you think of it, as basic as, God forbid something should happen to you and your loved ones are left behind, how are they to know what you own and where it is, other than you give it to your solicitor, who will have the schedule there and will know where your assets are? And it's a good start point then for after your day for your executor to be able to identify where the assets are and to gather them in. That's what I ask people to prepare. Come in, sit down, let us know what it is you think you want to do, and then we can get them.
People be nervous coming in.
They do.
I think people in their mind, and I don't equate it to going into a doctor's.
It's quite a morbid thing to do. People
think
feel
it's in that space that
it's uncomfortable.
Yeah,
because you have to bring your mind to an uncomfortable place, particularly if you have minor children. Greg, I don't know if you have children, but people fail to see that if they have minor children, then they should really be making a will to provide for the minor child. Yeah. God forbid both parents are in the unthinkable catastrophic accident, leaving minor children behind. I mean, your will allows you to appoint a guardian of those children and trustees for those children. And the fallback position is, if you don't appoint them within your will, testamentary guardians and trustees, then in the event of competing interest among family members as to who should take them, it's a court application. Yeah. And who wants to do that? No, every parent would want to make that decision themselves, as opposed to a court judge.
And even your language and how you're saying it, incredibly sensitive. But the reason we have to talk about it is because it happens. Yeah. Okay, the worst happens. It does happen. Yeah. Now, it doesn't happen all the time, thankfully, but it happens, and it's happened to people that we're listening to. Yes. And I think that's a really important one you're talking about when it comes to younger children particularly. And
I mean, people often think, I don't have many assets, I don't have an estate. Well, if you have children, that's as much an estate as you need.
Yeah, for sure, okay. So I presume this is across the board and not necessarily unique to your practice, about the 3 levels of service. In other words, what you provide, okay? Yeah. So I think we've talked about the basic will with title review, where I go in and say, I've got a house and I want to go here. Is that
That's
what
right.
that is?
That's
right.
a basic will, yeah.
So then when it comes to tax and title review, is that when you maybe have numerous properties, or you have
numerous properties, or a sizable estate or land, as you say, or business assets that could really warrant tax advice for the disponer, the testator, the person making the will, and for the beneficiary? Because often estate planning can be lifetime transfers as well as leaving it in the will, so it may be more beneficial for the testator to transfer it during their lifetime, and also for the beneficiary to receive it, particularly if they can fit the mould for the taxation reliefs and the stamp duty reliefs and all of that,
So say I wanted, for whatever reason, to leave a child the property, right? But I also wanted to live in it until such time as yourself. Would that be part of a will legally, or part of a visit to you that would legally lock that in? Can that be legally locked in, or could the child get some notion and say, right, I've got it in my name now, out you go, Pops?
You can do a voluntary transfer, so during your lifetime. And what you're talking about there is called an exclusive right of residence. So the parent wants to transfer the interest of the property now to the child, but they're going to retain what I call an exclusive right of residence. So only they can reside there for the rest of their lives. That can be done, yes.
Right. Talk to me about a power. And then now, of course, then the full estate plan, I think, is much of what we talked about, bells and whistles. Yeah. Is the enduring power of attorney an important element of that needs particular mention?
It is. You'll recall at the very start I said an estate plan is dealing with your estate and affairs for both during your lifetime and after your day. So the EPA, the enduring power of attorney, is the during your lifetime aspect. So what it does and what it allows you to do is to appoint an attorney and a trusted individual to make your life decisions, if you like, in the event that at some point in the future you become incapacitated, that you cannot do it yourself.
Well, listen, there's questions coming in along those lines, so it does. So that is someone the enduring power of attorney then is someone who can make decisions on your behalf whilst you're alive if you lose the capacity to make those decisions.
Yes, and the important thing is only if you lose capacity.
Yeah.
So it sits there. It's sort of like an insurance policy for you, that you have a nominated individual nominated to make those decisions for you. Because
now, can you have a succession within that? In that, let's just say let's just say I did become incapacitated, and the person that I've entrusted to look after my affairs themselves succumbs, right?
Okay, so what you're talking about there is a substitute attorney, and the document does allow for as many attorneys. So if you wanted 2 and then 2 substitutes,
get you okay, right?
So yes, you
good
can.
To cover that as well. Again, we don't want to talk about it, but these things happen, right? So before we get into some questions, maybe the default position when people ask questions, and I'm not saying it was mine, was that we're talking about a married couple. Right? So does any of what we've talked about change in terms of cohabiting couples, which is more and more common now, or even same-sex couples, for example? So maybe 2 men are in a relationship, cohabiting, has the laws and their rights, if they caught up to that of a man and woman married or cohabiting, for example?
No. So there's huge differences there, and it's a huge area that needs to be explored and properly put in order if you wish to benefit your cohabitee. Firstly, I should say that cohabitees are not automatically entitled to any share in the estate, even if there's no will. So if you pass away without a will, your cohabitee is not entitled, gets nothing. You may have a situation where people are cohabiting but yet were previously married and may not be divorced because of the costs of divorce, and could be cohabiting for 10, 20 years in a previous marriage, still sitting there. If they die without a will there, in those circumstances, the spouse is still a spouse for the sake of inheritance.
I imagine there can be a great deal of challenge to that too, because the cohabitant might say, well, I've invested such and such, or we put this kitchen in together, or we did that extension. And then the wife or husband might say, well, we built that house together and half of that's in my name. So I think actually that's a really, really, really important area that people need to get on top on, because society is changing now, and the laws and what have you aren't catching up as quick.
It's a huge avenue for dispute, and you have to remember that disputes in the estate almost eat all of the money in the estate. Cohabitees, if they are benefiting under a will, and you want them to benefit under your will, the second thing you need to be aware of is that they are strangers in blood as far as the revenue are concerned. They are not family members to you, they're strangers in blood. So they get the lowest form of tax-free threshold allowance, which is 16,250. All right. So again, they're in a difficult position there, trying to benefit each other on their death. But there are measures that you can take to try and counteract those tax consequences that can be catastrophic there. So good financial planning is what is needed there for cohabitees. There are policies that you can put in place. Now, I'm not a financial advisor, but I do know of these policies. One such policy is called, they're life policies, but they're very specifically named the policy on the life of another. So the cohabitees would take out a life insurance policy on the life of the other.
Get you.
Pay the proceeds or pay the premium out of their own bank account. What that does is, on the death, untimely death of one of those cohabitees, the premium is paid to the surviving cohabitee tax-free. So the full premium is allowed to be paid tax-free because they've paid the premium on the life of the other. And that money then can be used to offset any capital acquisition.
Now, I know to some extent I've probably thrown a cat in the works, and we're not going to get it all sorted and cleared up today.
Okay.
But I think what we've done is we've highlighted the importance of actually maybe people who are listening to this in that situation go, right, I never thought about that. And then they can get in contact with the likes of you and start sorting it, because I think, and it can be explained in more face-to-face detail at that point, but I think it's just really, really worthwhile. Right, let's get to some... I don't know what to do here with the time we have. Can the executor of a will also receive something under the will?
Yes. In fact, I think it's more beneficial, because then they have a vested interest to come in to you to do the job, to get the estate tidied up, and ultimately they'll benefit themselves. So yes, you can.
What does the word probate mean?
Probate is the process of administering the estate after the person has died.
So lots of questions we get about, the will's been in probate for 1 year, 2 years, 3 years. Yeah. What's going on there? Can that be? It can't be fast-tracked as such, can it?
Fast-tracked, it depends how efficiently worked at the file the probate is, but What I will say is the executors are allowed 12 months, which is called an executor's year, to gather in the assets and the liabilities and to determine what's in the estate. After that, you would be hoping that you can have enough information to submit all of the information to probate. Your hands are then tied to some extent when you do submit it to probate. The current waiting time for a grant to be returned is 20 weeks. So you've already nearly 18 months, there gathered up. And then after that, when your grant is returned, you can then begin to call in all the assets, the monies in bank accounts, life policies, change the property ownership. So in all, Greg, it's very hard to put a time frame on it. Allow
up to 2 years.
Up to 2 years, okay. 18 to 24 months. Actively being worked on.
My mum's getting a little bit forgetful. Can she do an enduring power of attorney now?
That depends on the level, I suppose, of forgetfulness.
And who judges that? Is it a doctor?
It's a GP, yes. So that's the first protocol is the GP for these EPAs. They have to confirm that the individual has the capacity and the understanding and the knowledge to understand the document they're signing at the moment. So if that level of forgetfulness is something in the lines of Alzheimer's dementia, then it's too late. And as we say, it's too late when it's too late. These documents need to be put in place when you're well and, and you're full of your health.
Exactly. We're not going to be able to get to an answer to this as such. Is it possible to discuss the rules and laws around inheritance in Ireland? I live in the north, but I have a property in Donegal, but I want to leave it to a niece in Donegal. Now, is that particularly complicated? As I say, I don't think we're going to be able to get through it now, but it's doable.
It's doable. The best practice, and we always tell people, is you do a will in the jurisdiction in which you own the asset. So that person needs to come out here and make a will in this jurisdiction, which deals specifically with the asset in the Republic of Ireland only. So that's what that...
We made a will as a couple, but we've got separate bank accounts as well as separate credit union accounts. We have 2 children, which everything will be divided between equally. Would we be better putting those accounts into one joint account? Handier, but is it needed?
Well, what the joint accounts do, what joint assets do, they automatically pass to the survivor. So it takes those assets out of the need for a grant of probate to be extracted. It automatically passes to the survivor. So yes, it is beneficial. I feel it's very beneficial.
Is it possible to add an adult child onto the deeds of their house while they're still alive?
Yes, it is. Yes, that's a voluntary transfer again. So it's obviously a parent considering transferring the asset. You can.
Is there a tax implication for that?
There may well be, but that would depend on the value of the house.
Well, come here. Listen, it's been really, really interesting, and we kind of only scratched the surface. So we'll have to do it again, I think. And we've done a lot of the groundwork, so we can maybe even just get straight into other stuff. Gillian, anyone with any further questions can contact Gillian McGough, Associate Solicitor at McElhinney's and Associate Stranorlor, or any solicitor.
Can I just mention, Greg, that if anyone is interested in our estate planning service, we have a brochure uploaded onto our website on McElhinneyAssociates.com. There's also a will instruction sheet, which is a very good start point for anyone considering making a will. I would just advise log on, fill out the sheet, drop us a line. And in 3 or 4 words, what's your view on people going online and doing wills themselves? No, it's a no. Homemade wills, solicitors don't like homemade wills. They are particularly difficult to get through the probate office. Unless you know what you're doing. I wouldn't advise on homemade wills. Gillian, have a lovely day. Thank you for your time. Thank you.